everyone. So we're going to finish up this chapter talking about offenses against public morality. So in the last lecture, we talked about public order offenses. Now we're going to talk about public morality offenses. Okay, so let me share my PowerPoint. Hopefully you can see it. So we're going to talk about public morality offenses. So my first question to you is, what crimes would constitute a crime against morality? What do you think is considered a crime against morality? Okay. Well, generally, these are what are called vice crimes, things that we as a society have considered bad, and we don't want people to do them. We consider them vices. So oftentimes, if you have a vice squad, it is a squad that's going after people for these types of morality crimes. Oftentimes, they're also referred to as victimless crimes. So these are crimes where the idea is the only person being hurt is the victim themselves. They're not hurting anybody else. They're hurting themselves by engaging in these activities. So you oftentimes hear morality crimes referred to as victimless crimes. That's debatable whether they really are, but that's what they are referred to. Now, under common law, there were different crimes that fell under what we would call morality crimes. So these were obviously crimes that were listed in the Bible, and they carried on, they were moral values of society, and they were considered moral crimes. So obviously murder is part of the commandments, thou shalt not murder. So it was a morality crime. Failing to attend church, because religion was very important during those times, taking the Lord's name in vain, blasphemy. So these were what were considered the more general common law morality offenses. Now, we have the Supreme Court, who really was in the business of upholding these crimes originally. It was believed that it was the government's job to regulate morality, that they played a significant role in deciding how we can keep society and the morals and values of society at a proper level. And we really did believe that the government was supposed to do that. But the question always comes up is, whose morality are we using to uphold for the whole country? So we have to think about, what is the standard? How do we set the standard for moral or ethical behavior? Do we use an 80-year-old woman, your grandmother, and what they think is moral? Do we use an 18-year-old college student and what they think is moral? Do we use a priest or a rabbi or a religious figure? Do we use a drug dealer? So whose standards are we using to determine whether or not something is moral? And that's always a significant issue. So when we were talking about these moral issues, we have to figure out what the Supreme Court has said over time. So one of the things we know is that the Supreme Court originally said the state can do it. But that has changed in current times. The court has moved more and more away from regulating these morality crimes and has decided that it really should be neutral. The government should be neutral on morals. It's too hard to decide what is a standard that applies to all people equally. And the courts have basically taken a hands-off approach and said, you know what, you can't really regulate morality, and we're going to stop trying to regulate morality. It's just too hard. Okay. Now, there are certain offenses that do fall still under morality offenses. So even though they try not to get too involved, there are certain offenses that we do find still in the laws. The first one is obscenity. So we need to talk about what is obscene. Okay. So let's talk about the history of obscene. It first was banned in the United States in 1800s. That was the first time we actually decided that if it's considered obscene, it is going to be banned, and it's legal to ban it. But we had to define obscene material. What is actually obscene material? So the court's first attempt to define obscenity was in Roth versus US. And what the court said is if something is obscene, it does not receive First Amendment freedom of expression protection. So some of the arguments are that, it's freedom of expression. We can create these things. We're expressing our feelings. We're allowed to have these materials. But the Supreme Court said no, it doesn't receive First Amendment protection if it is declared obscene. So then we had to define obscene. What does obscene mean? Well, basically, obscene material has been defined as utterly without redeeming social importance. So something that has no social importance. Well, that's still very, very vague. But based on that definition, you started to have more and more states starting to pass laws. So the federal government said you can regulate it. States started to pass more and more laws regulating it. But it still constantly was plaguing the court. How do we define obscenity? What do we use to define it? We can't let it be vague. We have to have an actual definition. So eventually the Supreme Court said, okay, we'll define it. I know it when I see it. And that actually came out in the Supreme Court decision, and that's how they defined obscenity. We just know it when we see it. Again, though, very vague. Does it really define obscenity? It doesn't really give us a good definition of obscenity. So that was in 1964. It wasn't until 1973 where the court actually started to define obscenity. And this is the definition they came up with, and this is still the definition used today. And if you look up obscenity in New York state law, we use this exact definition for obscenity. So in order for something to meet the standard of obscenity, it has to meet 3 requirements. Number 1, whether an average person applying contemporary community standards would find the work taken as a whole appeals to prurient interest. So the first thing is that the work would have to be deemed prurient. So what the heck is prurient? And I'll go back to that slide. So if you didn't write it all, that's okay. I'll go back to it. We have to define prurient. So the court defined prurient as arousing or appealing to sexual desire in a sick or morbid or shameless manner. Okay, so I define it as sick sex. So if you depict sex in a morbid or sick or shameless manner, then that is obscene. So in order to meet this definition now, we have to show that it's basically sick sex, that the average community would look at the work and say, oh my God, that's a sick, morbid depiction of sex. The second thing you have to prove is that it's patently offensive, meaning that people would look at it and say, that is super offensive. So we need to talk about what does that mean? Well, how do we measure that? We'll talk about that in a minute. And then the last thing is whether the work taken as a whole lacks literary, artistic, political, or scientific value. So what the court is saying is if it is artistic or political or literary or scientific, that's a form of expression and it's protected by the First Amendment. So it's only obscene if it's not deemed literary, artistic, political, or scientific. Otherwise, it will receive First Amendment protections. So remember, in order to show something's obscene, you have to prove each of these 3 things. Okay, so we already defined prurient. Now, so the next court case that came out was trying to figure out those standards. How do we as a community define each of those things? So the first one, whether it's prurient and patently offensive, the court said you use what we call a contemporary community standard. That means the community that you live in, where the material is. So it can vary from community to community. So New York may have a different contemporary community standard than Miami, than California. So you look at each individual community and figure out what would be prurient or patently offensive in that particular community. So that can vary. The last one, though, whether it is artistic, literary, political, or scientific, we have to use what we call the reasonable person standard. That means as a whole, the whole country, what would be reasonable? Would a reasonable person in this country view it as artistic or literary or scientific? So that's not specific to your community, it's specific to the whole country. So it's different standards for different parts of the test. So parts 1 and 2 use contemporary community standard. Part 3 uses a reasonable person standard to determine if something is obscene. So now we need to think about, what about porn on the internet? What is the community standard for the internet? So we have contemporary community standard to determine what's prurient and what's patently offensive. Well, if it's on the internet, what's that community standard? Well, it's the whole world. So what is patently offensive to the whole world? What is prurient to the whole world? Okay. And so it has caused a really big difficulty on the internet to stop internet pornography, because there's no community standard that really makes anything reach that standard. There's nothing that bad that reaches that standard. Now, there's a couple things that have still been found to reach or to be prurient and patently offensive on the internet. Anything with children, and we'll talk about that in a minute, but anything with very violent rape scenes also is considered beyond standard community standards. So super violent rape scenes and children, those are going to violate community standards, even on the internet. Okay. So is it just criminal to create obscene materials, or is it even a crime to be in possession of them? So are we only going to go after the people that create them, or are we going to go after even people that possess them? Well, the Supreme Court said in general, it is not a crime to just possess obscene materials. It is only a crime to make them in 1969. Now, remember, children are not going to fit into this, and we'll talk about that in a minute. Okay, so this is non-child pornography, and so you can be in possession of pornography. There's no crime to it at all, as long as it doesn't involve children. So if you were a police officer, would you be able to determine if something is obscene? So if I showed you this, is this obscene? So the first, is it prurient? Is it sick sex? Well, probably not. It's just a naked picture. There's no sex depicted. It would not fit the definition of obscene. What about this? Same thing. It's not really depicting sex or sick or morbid sex. So this also would probably not meet the definition of obscene. What about this? Well, maybe you could say that, even if you think this is showing sex, which it's not really, but if it is, if you're saying yes, it is, then the question is it patently offensive? Well, maybe some communities would say this is offensive, but then we get to this question at the bottom. Does the reasonable person view this as literary, artistic, scientific, something like that? And it's art. It's a famous piece of art. So it is not obscene because it doesn't fit the third part. Well, the last one, what about this? This was a billboard that went up in New York City, actually. And parents were really upset because they were walking their kids by it every single day. And this was close. It actually was taken to court. So is it sick sex? You could argue in a community that it is sick sex involving 3 people, and it's patently offensive in that community. And also you could say that there's no artistic or literary or scientific value. It's an advertisement. It's meant to sell underwear. So this was close, and they were forced to take this down because it was close. What about this? Would this be obscene? So we said children, but the question is there sex? Is it prurient? Is it patently offensive? So this was an advertisement for underwear for Calvin Klein for little kids. And there was several different pictures depicting children in their underwear. And it went to the Supreme Court because they wanted Calvin Klein to take this ad down. And the Calvin Klein company said it's not prurient and it's not patently offensive. And the Supreme Court said if it involves children, it doesn't have to be prurient or patently offensive. We have a much broader definition of obscene, and it would not be constitutionally protected. So they had to pull the advertisement. So if it's dealing with children, we don't allow, we are much more prohibitive, or I said, we include a lot more under the definition of obscene, which says it's not protected under the Constitution for children. The other thing that came out with children is it is a crime even to possess. So general pornography, you can possess, it's not a crime. If it's children, it's even a crime to possess. And that's what exists today. Now, you always have crazy people that think of crazy things. So then you had people developing what we call virtual child porn. So they weren't using real children. They were using avatars or, developed pictures with fake children. They weren't really children. And the federal government said, no, you can't do this. And the company said, yeah, we're not even using real children. It's fine. Well, the federal government did not like it, and Congress passed the Child Online Protection Act of 1998. And this basically says you cannot even use virtual children. You cannot create or possess anything, even if they're not real children. Okay, so that is obscenity. So now we need to talk about a few more obscenity or morality types, not obscenity, morality types of crime. So another crime that falls under morality is gambling. So gambling is placing money or bets or wagers on a game of chance or sporting event in hopes of realizing a gain. So in order to prosecute somebody for gambling, you need 3 specific things. Number 1, you need consideration. Consideration is an exchange of something of value. So I will give you something, you give me something back. So I need my house painted. You give me your time and energy to paint my house. I give you money back. That's consideration. So each person is exchanging something of value. You need a prize, and it has to be a game of chance, which means the person cannot control the outcome of what is occurring. Okay, so you need those 3 things to qualify as gambling. So what do you think of this? To promote the sale of Best Burger, they offer the Hamburger Inc. offers a chance to win an all-expense trip to Bahamas to anyone holding the winning number. It's in their advertisement that if you may have a free ticket if you just send a letter and request one, that you don't have to actually purchase anything to win. And they make the drawing every first day of spring. So when we think about that exchange of something of value, does each side have to exchange something of value to participate? And in this case, no. So that is how, like, Roll Up the Rim to Win and McDonald's Monopoly and those games are okay, because you can get free tickets in the small print without having that consideration. What about this? Sally Fair and her friend Jimbo Midway attend a local carnival. They operate a game where you pay $1 to throw a basketball into 3 metallic objects shaped like milk bottles. If you knock them all down, then you win a prize. So Sally persuades Jimbo to pay $1. Jimbo does and wins the prize. So again, is this gambling? Consideration? Yes. You're giving money. You're giving me a chance. That's consideration. Prize? Yes. Last question. Is it a game of chance? Do Sally or Jimbo have any control over the outcome of the game? They do, because it's based on skill. So certain games that have skills destroy the last requirement for gambling. They're not a game of chance. They're a game of skill, and therefore it's not gambling. And then this last one, trying to win $1,000, Rainbow pays $5 for a number on a drawing the following Saturday. The numbers are just randomly drawn from a pot. Consideration? Yes. Giving money to get a chance to win. Prize? Yes. Does Rainbow have any control over the outcome? No. this is gambling. So remember, for gambling, you need all three things. Now, what about gambling on the internet? Fantasy football leagues, those kind of things. Is that gambling? You have consideration. Absolutely. You pay money to be part of the league. Is there a prize? Sometimes there's a prize. The last question, is it a game of chance? This is often where the debate comes in. Is it chance or is it skill when you're part of these fantasy football leagues? For a long time, New York took the position that it's chance. And just recently, they changed their laws and said that these could operate in New York because they are a game of skill. So that's where we stand with that. Okay, so the last category of morality crimes that I want to talk about are what we consider consensual sexual conduct crimes. So we spent a whole week talking about non-consensual sexual acts. These are consensual sexual conduct. These are when the parties consent to engage in the sexual acts, okay? These can be morality crimes. They're not sex offenses because you have consent. Now, under common law, there was a whole bunch of offenses that fell under common law or ecclesiastical offenses. So these were the main ones: fornication, adultery, seduction, incest, bigamy. So fornication is sex prior to marriage. This was considered a common law offense, morality offense. Both parties agree, but if they weren't married, it was considered a morality crime. Adultery is when one or the other or both parties are married to someone else and engage in sexual intercourse with each other. That is adultery. Again, consensual. The parties consent to engage in the sexual activity, but they are married to other people. New York still has adultery, so it's still a morality crime. Seduction was a common law morality crime where the male would promise marriage in order to have sex. That was defined as seduction, obtaining sexual intercourse with a false promise. So it was still consensual, but it was based on a false promise. That was called seduction. Incest is engaging in sexual intercourse with somebody that you're related to a certain degree, a first cousin, a second cousin, something like that. Again, completely consensual. Both parties agree to do it, but the law does not want them to because they are related in some way. And the last one is bigamy and polygamy. So bigamy is being married to more than one person at a time. So two people being married to the same person. Or polygamy, many wives, and you're already married to somebody. These are also common law or ecclesiastical offenses. So I have a little video about bigamy and polygamy that you can click on and watch if you would like to. There's always a question is, why is this bad if everybody consents? If they agree to be the wife with multiple women to men, there's very few, there's very almost minimal cases of multiple men married to one woman. It's almost all multiple women married to one man. So the question is why? Who cares? If they want to, if everybody agrees, why is this something that's bad? And it's a debate in our society, not too strong, still considered very strong morality crime, but it is something to think about. Now, one of the last things I want to talk about is sodomy. So sodomy was originally defined as a homosexual sexual intercourse. So we defined it as oral or anal sexual conduct, but non-consensual. So here I'm referring to consensual homosexual activity. Originally, the Supreme Court said you can make this a morality crime. In Bowers versus Hardwick, they challenged a sodomy law, and the Supreme Court upheld it and said it is a morality crime. It is okay for a state to make homosexual sexual conduct a morality crime. So that was in 1986. That issue was brought back in front of the Supreme Court in 2001 in Lawrence versus State. And the Supreme Court said unconstitutional. If it's consensual sexual conduct, people have the right to privacy, and you cannot make it a morality crime. Okay? Now, prostitution is also considered a morality crime. Prostitution is engaging in sexual acts for something of value. So somebody agrees to provide a sexual act in exchange for money or something of value. That is a morality crime. Again, consensual, the person agrees to give the sexual act, and the person agrees to pay them. It's a consensual thing. But we view that as a morality crime. Now, we have certain crimes that are included in this. There's a Federal Prostitution Act, which is called the Federal Mann Act. This makes it a federal crime to transport prostitutes across state lines. So if you know somebody is engaging in prostitution and they are transported across the state line, that better violates the Federal Mann Act. Obviously, part of the way to curb human trafficking. We also have different crimes for solicitation. So soliciting the prostitute or patronizing a prostitute, that is going after the people that are paying for the prostitutes. And then we have certain crimes that are pimping or pandering. That's a person that sort of runs multiple women in this business. We also have the crime of indecent exposure, or we call it exposition or exhibitionism. So this is exposing yourself. This is they have the trench coat and they like show themselves in public. That is considered a morality crime. We also have voyeurism. Voyeurism is peeping toms, looking through windows and watching people change or just, are naked or engaging in sexual activity. That is voyeurism. We also used to have a morality crime of profanity. So it was against the law to say certain words in public. So the F word is a perfect example. And your parents probably, or your grandparents probably called it obscene. Oh, that's obscene. Well, we now know it's not obscene because it doesn't involve sex. But we still called it profanity, and it was against the law. Almost all of the profanity laws have now been declared unconstitutional as overbroad because they violate people's First Amendment rights to free speech. So it's very hard to find profanity laws. If they do exist, very few of them are enforced anymore because they would violate First Amendment rights. Okay, so my last slide is, what do you think about all of these morality crimes? Should we have morality crimes? Do you like morality crimes? Do you like deciding what's moral and not moral in society? And if we do have them, which ones? Which ones should we keep? Which ones shouldn't we have? So just think about that, because that's always a consistent issue when you're talking about morality crimes. These are definitely malaprohibita crimes. They change as society changes. Many morality crimes that existed in the past don't necessarily exist today. So the question is, should we have them at all? So that's food for thought for today. So that is all I have. That is the end for this week. And then the only thing we have left is to talk about crimes against the state. So I will see you soon next week with the last lecture.